All right, well, welcome on this nice day. I really appreciate you being here. This is an interesting topic. I get a lot of questions about that. I'm sure you get a lot of questions. So I'm Vivian Armour. I think most of you know me by now. I'm the program manager for the Alex Brown Center. And we do a series of these workshops. So this one today is going to be on Intellectual Property 101. And next week we're going to have one on supply chain, something everybody's talking about. And supply chain is going to impact you no matter what. So maybe we need to understand how involved it is and how it could impact you. And then, of course, next Thursday night, we've got the idea competition, so we really hope we'll see you there. Because you may hear some ideas in that competition that could benefit from this talk today. So let me introduce our speaker, Robin Hylton. She's been very gracious. She was kind of filling at the last minute because we thought someone else was coming. They had to meet another commitment, and Robin, thank you for stepping in. And Robin, as you can see, is the Assistant Outreach Coordinator for the USPTO, United States Patent and Trademark Organization. So again, important topic, IP 101, that's where I need, or 0.00 for me. But thank you for being here. And you're not new to UMBC, you've come before. Okay. So we welcome you back, Robin. Thank you.
So we had to change the name from IP 101 to IP Fundamentals because there's a case law dealing with 101. It was kind of confusing, so it's now IP Fundamentals. So a little bit about me. I was a patent examiner in the container closure and flexible bag arts for 20 years. I moved over to International Patent Legal Administration, so I work with the international patent applications. And I'm on detail with the outreach office, which will be coming to an end all too soon. So we're slated for an hour. It probably won't take me an hour to go through this. So if you have questions, feel free to ask questions, or you can wait until the end. But hopefully it'll be pretty self-explanatory. A little chain down here, but that's okay. Disclaimer, I am not allowed to give you legal advice. This is for informational purposes only, but I'll be more than happy to help you with your questions as long as you don't take it as legal advice. Are we good? All right.
Fair.
So today we're going to discuss these three main topics. IP as a business strategy. What is intellectual property? What and where is the USPTO? We're going to cover the 4 types of IP, trade secrets, copyrights, trademarks, patents, and then I'm going to give you a brief introduction to resources that are available to you through the USPTO. In case you haven't noticed, there's a lot of acronyms. USPTO, rather than saying US Patent and Trademark Office, just USPTO, and IP for intellectual property. That's what we do in the government. IP is a strategy. How many of you have ever seen Shark Tank? And you notice that Laura Grenier usually asks, do you have a patent on it? Right? Because she wants to invest. And she wants to know that she's going to get a good return on her investment. So she wants to know if your invention is protected by a patent or if you have a trademark. And that's because it's attractive to them, because that way they know, if you have a patent on this, you have a trademark, good probability that I'm going to reap benefits on my investment. So that's why you should consider that. It deters infringement lawsuits. So if someone has something similar to yours, but you have the patent, well, they possibly can't sue you because you already have the patent on that invention. It will leverage your power when you talk about mergers and acquisitions, as well as it will add property right value to your company. And we are in a global economy, so you need to be sure that you have patent protection. There is no such thing as an international patent, but you can use the International Patent Application Filing System to get patent protection in other countries. And I'll talk about that very briefly at the end if anyone has any questions about that. So what is intellectual property? And how is it different from real property? Real property is something that you can see as tangible, right? Real property is something like a house or a car or this table. Versus intellectual property, it is something that you own based on either a product that you have. It can be based on a manufacturing process. So it's not an idea, it's actually something that you've developed, but is still considered intellectual property. So what is USPTO? The U.S. Patent and Trademark Office, the headquarters is located in Alexandria, Virginia. We have 4 other satellite offices, Denver, Dallas, Detroit, Silicon Valley. And we consider ourselves the innovation agency. And what we want to do is to make sure that we have a strong patent system. And that's what we're working towards, is making sure we have a strong patent system that any trademark or patent that is issued is valid, because we want you to go to the bank and not to the courthouse. So that's what we're striving to do. In fiscal year 2021, there were almost 13,000 employees. And of those, more than 8,000 were patent examiners. We have trademark examining attorneys, administrative patent judges, administrative trademark judges, and we have other support staff, as well as human resources, finance, things like that. There were 650,000 plus patent applications filed in fiscal year 2021, and there were 374,000 patents issued. Now, these weren't necessarily from those. It could have been from those that were already had been filed previous to the fiscal year 2021. Trademarks, almost 1 million trademark applications were filed in fiscal year 2021. There was a huge boom in trademark applications filed during COVID. There have been some issues, and the patent office is working towards those, because we realize that some of those are not valid trademark applications, because there are a lot of them came from China, and so we're working to deal with that. But there was a huge boom. So there's taking a little bit longer to get through the trademark applications than historically available, but we are working to get those down as well. Historical foundation for intellectual property. Founding fathers put in the Constitution that Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So we have a constitutional foundation, and that's why we have a patent and trademark office. And by the way, if you're ever in Alexandria, feel free to stop by and take a look. We have the National Inventors Hall of Fame. There's a museum there, and it's pretty interesting if you get a chance to stop by. So I said we're going to talk about the 4 basic types of intellectual property. So there's a patent based on your new or inventive idea. There are trademarks, which identifies your goods or services. We have copyrights, which deal with the creative expression stored on a tangible medium. And we have trade secrets. That's information that's valuable but kept confidential. And we'll go over a few examples of each. As you can see in this mobile phone, we have all 4 types of intellectual property. We have the trademarks, the Apple name and logo, as well as the iPhone's trademark. So you know that comes from that company, right? We have copyrights based on the software code, the instruction manual, and the ringtone. We have 2 types of patents. We have the utility patent based on the process, data processing methods, the semiconductor circuits, antenna, etc. We also have what we call design patents, and that's based on the design of what it looks like. So the overall look of the phone, as well as the arrangement of the camera and lenses, and as well as the buttons. So those are the 4 basic types, with 2 of them being patents. So let's talk about trade secrets. First of all, are there any questions so far? Yes.
There was a slide talking about the amount of patents that were that people applied for or something. How many of those actually get accepted?
So we're going to talk about the patent application process, reviewing from start to finish in a future slide. But there is a data utilization table on our website that shows you the rate of issuance, as well as the length of time from filing to first action to what we call final disposal, which is either an abandonment or an issuance of the patent. So you can find that information on our website, uspto.gov. Okay?
Cool.
Good question.
There's
Trade
another one
secret.
back here.
Oh, I'm sorry, yes.
Yes, so in terms of intellectual property that's more research based, what category would that fall under, or would that be a whole different office?
So it's going to depend on what you want to get the protection for. There's a lot of research, but you're either gonna get the patent on the method of using a product, the method of making something. It could be on, the product itself, so it just depends. You're doing research, so it just depends on what you define as your invention.
What about like intellectual property in terms of data you found or discoveries you made?
So the data, again, it depends on how it's used,
Okay.
okay? Secrets, Colonel Sanders' secret recipe for his Kentucky Fried Chicken. We don't know what's in there. People have tried to figure it out, but we don't really know what the secret ingredients are. As well as the Google, algorithm, we don't know what that is either. So those are trade secrets. But why would you wanna use a trade secret? Because you don't want other people to know what it is. You don't want them to be able to duplicate it at some other point in time. If you remember where it said for a limited time, people who had protection for their intellectual property. So once that time period has expired, someone else can then use your technology, your invention, improve it, and duplicate it. But with the trade secret, they can't do that. So if you work for a company where the trade secret is, there's probably some non-disclosure statement that you have to sign that you're not gonna disclose what the secret ingredient is. I don't know if it's actually kept in the safe or not, that's what they say with Colonel Sanders' recipe, I don't know. But whatever it is, you can't disclose it, okay? Let's go to copyrights. I'm sure you've seen copyrights before. It's actually recorded by the Library of Congress, not with the USPTO, but our director provides information to Congress regarding copyright protection as well. It is for the term, is for the author's life plus 70 years. So if you write a book, for your full lifetime plus 7 years thereafter, it is copyright protected, as long as you have filed it with the Copyright Office. Okay, it's a legal protection for the authors of original works of authorship, including literary, dramatic, musical, artistic, and certain other intellectual works. And as you can see here, songs, but they have to be on a medium. Songs, movies, you always see that in a disclosure of a movie. You're gonna go to jail for this if you sell our movies. Books, poems, even sculptures and paintings, and sounds can be copyrighted. Yes, sir.
The last slide said like the creator's life plus 70 years,
Yes.
right?
Mm-hmm.
What if the product is owned by a company? Is it the company's life plus 70 years?
I'll get to that in one second.
Okay.
You're ahead of your time here.
Okay, so again, this is just a listing of the things that are protected. Remember I said it had to be on a fixed medium? So just because you have a song in your head and you start thinking about it, it's not copyright protected. You have to actually put it on a disc, put it on paper, something in order for it to be protected. Again, so where it says fixation need not be directly perceptible as long as it may be communicated with the aid of a machine or device, your voice is not considered a machine or device, okay? Okay, again, original work of authorship, meaning that the work must be independently created by the author as opposed to copied. The US has required a modicum of creativity for copyrighting something. Other countries, laws may be a little bit different, and that goes for patents as well. You have to keep that in mind. But we're not gonna get into that because we're talking about fundamentals. Yes, sir?
So, given that copyright protects someone else from using their work to make money, so we can use other people's work, but we don't get money from it, it's still legal? I know you know how legal advice.
Right, so if you want to use part of someone else's song, there have been a lot of people that have been sued for using part of a song because they didn't get permission to do so.
But you use it, but you don't make money off
It doesn't matter.
It doesn't, okay.
You can't use somebody else's intellectual property for your own purposes
But
without their permission.
how would you go about, like, let's say, news organization using what you made to critique or criticize? How would you categorize that part of using that copyright material?
So if you're going to quote it, you
Mhm.
could quote it, you provide your source material, you provide the source in the footnote, that's okay. But if you simply just copy it and don't tell what the source was, that's not okay.
So as long as we provided where it's coming from.
You should be able to provide where it comes from, but if you're copying like the whole thing, you should probably go to that source and ask them, is it okay for you to use that entire,
Okay.
yeah, but just like little quotes, little things here and there, that should be okay. Just like when you're writing your term papers, you know, you have to put in your footnotes where your source of information if you quote something. But if you put the entire thing, that's why they talk about originality in your term papers, same thing. You can get a copyright on compilations or derivative works, but again, you have to have permission from the owner in order to do that. So what is not protected? Something that has not been put on a fixed median. Titles and names, familiar symbols or designs, okay? Just because you change the lettering of something doesn't mean it's copyrightable. Merely listing the ingredients or content, you cannot get that. You cannot patent, copyright, or trademark an idea, okay? No ideas, you can't do that at all. And works consisting entirely of common property containing no original authorship. Again, it has to be original authorship. All right, here's where we talked about, here's the answer to your question, young man, okay? So for a person is life plus 70 years, okay, after their death. If the author is not a natural person, the copyright lasts 95 years from publication or 120 years from the creation, whichever expires first. Okay. And that recently changed in 1978. And I believe that was at the bequest of Disney, because I believe Mickey Mouse or one of those characters, the copyright was about to expire. So that came from that. Okay. This is what the exclusive rights of a copyright owner has. They can reproduce the work, they can prepare derivative works, distribute copies, perform the work publicly, display it, and they can also authorize others to use it. Why should you register? Because you want to put others on notice that you have permission, you own this particular item, whether it is a song, if it is a sculpture, you want to be the author and the owner of that, so you want to put people on notice. Excuse me, if you register it in the US Copyright Office, then you can file a federal lawsuit to sue people for using your copyrighted material. Okay. If you have something that's registered and people are importing pirated products, you can contact US Customs and Border Protection so they can block those things from coming into the US. Statutory damages and attorney fees may also be collected from the infringer. And it's easier to license your work, collect royalties, and enforce your rights outside of court. Okay, we're gonna move on to trademarks. So these will be available to you if you need them, okay? So don't worry, you don't have to try to remember everything I said. So what is a trademark? It's any word, name, symbol, or device, or combination of thereof that discloses to distinguish goods and services from others. So I'm sure you all know what these are, right? You know what that one is, right? Michael Jordan's, AAA, McDonald's, Girl Scouts, Macy's, Apple. So you see there's several symbols here. We have a TM, an SM, and an R. We're going to talk about those a little bit. So if you are using a symbol, name or word, whatever, if you're using that in business, you automatically have a trademark. Okay. If you want to protect it in court, you need to register it and receive a registered trademark, that's where you see the R, with the US Patent and Trademark Office. This one will protect you in your local area. This one will protect you in the US. So it's always best to trademark whatever you're using. In essence, just a service mark. Again, we already talked about this, but it's any word, symbol, design, or combination that identifies the source of your goods or services and distinguishes your goods and services from those of another party. Trademarks do what? They offer brand recognition so that you know, if you go to McDonald's, you see those golden arches, you know that you're gonna get the same Big Mac at this McDonald's as you would this McDonald's, there's one across the world, right? So you know that. So it gives you that confidence that's gonna be the same. Again, public notice of ownership, exclusive right to use it. It gives you the right to enforce it nationally and to bring legal action. When you have the R, and the only time you can have that R is if it's federally registered at the US Patent and Trademark Office and you receive that registration. It gives you the right to record your mark with customs, as I said before. It is the basis for filing foreignly in other countries across the world, and of course it's published in the US Trademark Database. Here are types of trademarks. All of these for a Coca-Cola company. So you see, you just have the word, you have the composite, you have a special form, as well as the design. And they have, all of these are trademarks for Coca-Cola company, right? So you recognize that immediately. Here are other trademarks. They can be a sound, a color, or a smell. So we've got the TikTok here. Owens Corning Fiberglass, they have this pink that's trademarked. This Robert A. Blue Tiffany box, everybody knows that you see that, it's a Tiffany's box, right? So that's trademarked. The Hershey's. Another sign, another smell would be Play-Doh. Do you guys know about Play-Doh? I mean, you're a little young, so I'm not sure you know about Play-Doh, but anyway, Play-Doh has the smell of that is copyrighted as well. And then of course, if you go into this store, what store is that? Apple. They have that trademarked as well. Yes?
I'm confused how a color can be trademarked.
That's what the I'm a former patent examiner, not a trademark attorney.
Yeah.
But, yes, they decided that you can trademark, because, for instance, if you have this Corning, if you have this installation, you know that it's from the Corning company, Owens Corning Fiberglass. But if somebody else were to try to use it and it wasn't of the same quality, who are you gonna look at to say, this is some bad installation?
Yeah.
Okay, so they wanna protect that protect their service and their product by trademarking the company. The same thing with Tiffany. Any woman getting a box with that color, they know that that is a good product. They don't want some knockoff in that Tiffany box, and Tiffany doesn't want that either, because that ruins their reputation. Another sound that is trademarked is the NBC ding, ding, ding. It's also trademarked. So the strength of a trademark depends on the wording and the description. So you want something that's fanciful and arbitrary versus something that is very generic. If it's generic, it's probably weak in somebody, and you might not get the trademark registered. So here are some examples of some strong trademarks. Apple, Gap, fanciful, Microsoft, Xerox. So you recognize these, and you won't see these used for any other company, okay? Now, if you wanna use something like dry foot for deodorant, for feet, okay, that's suggestive, right? You wouldn't say dry foot and think it's for, plant food, right? So suggestive, so those are good ones to use. Here's some examples of some weak ones. Urban housing for real estate services, or apple pie for potpourri. Something that's very generic, lawyers.com, we're providing online databases, or milk for a dairy-based product. Milk can be anything, so why would you trademark milk, right? talked about why you should register, talked about this before. You want to make sure that you can use this symbol, use the R in a circle, because it's gonna give you more protection across the United States. It allows for any goods coming into the US to be stopped at the border, as well as keeping people from making your product fraudulently. So these are all the reasons that we've discussed previously of why you should register your trademark. Before we move to patents, are there any questions? Yes, sir.
Would it be illegal to put the R on your, or to use it when you don't have something
Yes,
registered?
you can do that.
Okay, got it.
Good question. So what is a patent? It's the right to exclude others from making, using, selling, offering for sale, or importing a claimed invention. We talked about it having a limited term. Patents are territorial. Remember I said there's no such thing as a worldwide patent. If you want to get protection somewhere, you have to file a patent application as well as a trademark or a copyright in those other countries. No such thing as a worldwide protection. In the US, we have three types of patents. We have utility patents, and those are from 12 years from filing date. It includes a process of making, a process of using. It could be a machine, an article of manufacture, or a composition of matter. Design patents talks about the ornamental design. What does something look like on the surface? And that's 15 years from the date of grant. And then we have plant patents. Those are newly invented strains of asexually reproduced plants. One thing that, and those are 20 years from the filing date. One thing that you will notice is that the plant patent is in color, and it's the only one printed in color. That's so you can actually see what the plant looks like, because it's a new plant. The others are just in black or white. And I worked on the utility type of patent applications. So again, you have to decide, is my idea eligible for protection? You can't patent an idea, so it actually has to be a process of making something, a process for using something. It could be a machine, something you manufacture, or composition of matter. We do have, people can get patents on drugs, for instance. That's a composition of matter. So you have to, it has to fall in one of these categories in order for you to receive a patent grant. All right, let's talk about hurdles to patenting your invention. It must be novel. That's the term we use. Means it has to be new, not described in the prior art, not known. Prior art can be anything. It could be a website, it can be another patent application that's already been published, it could be a granted patent. It could even be a disclosure in a research document. So anything that's already disclosed to the public can be considered prior art. So if your invention is described in any of those things, it is not novel. The next test, is it non-obvious? Meaning, what is the difference between your invention and the prior art? So if there's a difference that is not obvious, so let's say if I have, for instance, if I were to say, I have this red tip, would it be obvious to make it green, to change the color? Right? So it's not non-obvious, so you wouldn't get a patent grant on that. So it has to be different such that it is not something that someone of ordinary skill in the art would say, it would be obvious for me to make that change, okay? And does it have utility? Meaning, is it useful? Can you use it as intended? Okay, I'm just watching your eyes to see if I need to say anything else about that. What is not patentable? You cannot patent an idea. It must be developed into a new, non-obvious, and useful machine, manufacture, process, or composition of matter that can actually accomplish the task. You cannot patent natural phenomena or abstract ideas. So So when people talk about a time machine, you can't patent that. Path to a patent. So here's your idea. Once you have your idea, you can then file what we call a provisional application. Provisional application is sort of, it can just be the bare bones of what your invention is, describe it, have a claim, maybe a drawing. Then you have 1 year to file your non-provisional application. Now your non-provisional has to have much more detail. We have to know, you have to describe it. You have to give us the background. Why are you coming up with this new invention? You have to have claims. If there are drawings that are necessary to understand the invention, you have to have drawings in your application. So that would be in the non-provisional application. This one is not necessary, but it's something that was developed September of 2012 with the American Invents Act. So this is something that's recently new. You don't have to file the provisional application before you file your non-provisional. You can just file the non-provisional. Your non-provisional, 20 years from the date of filing, okay? And hopefully you'll get a patent. Okay. Non-provisional applications are not examined or published. There's a 1-year time limit, so you have 12 months. It's only for utility patents and not for the other two. And again, it's just a low-cost way of establishing your early filing date for your non-provisional application. The non-provisional is examined, is published 18 months from the earliest filing date, unless you file a request to not publish it, and this one can become a patent. All right. Any questions before I go into this one? Yes,
Do you have
sir.
any sense of what percentage are non-published?
Of the non-provisional? No, I don't, unfortunately, I don't know. I don't think it's very many. It could be that if it's someone who intends to publish, intends to file an application abroad, I think those are the ones that tend to say, don't publish my application. Because the disclosure is very different, that time frame, because there's no statutory bar in other countries like we have in the US. Statutory bar just means that if I come up with an invention, I have, within 1 year, I can claim priority back to that one and it not be used against my new invention. That's what a statutory bar is, just for those of you who might be like, what's she talking about? All right, so we're gonna talk about the patent process. So you file your patent application, it comes here. More than likely, you're gonna get a rejection, meaning that the examiner has found prior art to say that your claims are not novel or they're obvious. Or you could get objections to the specification or to the drawings for some reason. Some applications are issued on a first action, but it's not, I would say probably maybe less than 25%. So more than likely you will get a rejection. At that point, it goes back to the attorney, or if you're filing it yourself, it comes back to you. You can then amend your claims and or provide arguments as to why you think your claims are different from what the examiner said in the office action, okay? So then it goes back to the examiner. The examiner could say, yes, I agree with you, go to allowance, you get a patent. The examiner could say, nope, I still don't agree with you, I'm gonna reject it again, comes back here. At that point, you can either abandon the application, meaning you're not gonna do anything else with it, or you can go to appeal. And that starts another process where you talk with the examiner, usually on paper, but you can go in for a personal interview. Start another process where you go through this argument stage again, and then we'll go to the Board of Appeals, and then you have patent judges that will then decide whether or not the examiner was correct in their decision, or whether they need to make a new rejection or whatever. Okay, any questions about this?
I'm sorry, just to clarify.
Yes.
So when you're rejecting, I mean, you're rejecting the entire application, even though some you're not necessarily rejecting every claim. Some claims might be valid, but there are not enough claims to approve the application itself.
Right, so you have an independent claim, so you have your first claim. I'm just gonna give you an example. I always go with the closure because that's what I know, right? So if you say, I have a closure comprising a top wall, a side wall, and screw threads, that's a very broad claim. That would be my independent claim. My second claim may then say, I have the cap of claim 1, further comprising screw threads on the inner wall. Okay, so now you've defined it a little bit better. But it's still broad because I can still find plenty of caps with top wall, side wall, inner threads on the side wall. So then you need to add more information. So let's say you get down to claim 5, and now you've put all this other information. Now you said the cap of claim 3, further comprising a spout with a hinge, hingedly attached to the top wall. Excuse me, and a drinking opening therein. So let's say I can't find that. Claim 1 is rejected. I'm going to object to claim 5 because I don't have prior art for it. So I'm still rejecting the application, but yes, so you have rejected claims, objected to claims, so that if you want to put all those limitations to the independent claim, now I can allow the case. Anyone, good, great question. Yes, sir.
So you're saying that when the claims that follow the initial claim have merit, as long as when you reapply or when you amend your patent, that goes into the initial claim, then it's more eligible for application granting?
Correct, correct. Now, the examiner should do an updated search just to make sure that they didn't miss anything or that something else didn't grant prior to your filing date. So there's a possibility that you may get another action rejecting that claim, even though you thought, both of you thought it was allowable to begin with. There's a slight possibility that, oh, I missed this, sorry, Mr. Applicant, I missed this, I need to apply this to your application claim, and then you just start the process again. Okay? And what happens is you have, so once you receive your office action, you have 3 months to respond, but you can pay for extensions of time for an additional 3 months if you want. And after that, if you don't pay, then the case is automatically abandoned. Okay, anything else before we go into resources? How am I doing on time? Okay, 12:40, all right. Everything you can find, uspto.gov. This is active, you can use that to get there. If you start here, if you know what you're looking for, you can just put it in this search tool. For instance, if you want to know how much is it going to cost to file my patent application, just put in fee schedule. It'll take you right to the fee schedule page. If you want to know more about patents, you can click on any of those or trademarks and get information. As an inventor or entrepreneur, and you're just getting started, you're not quite sure what to look for, this is probably where you should start. Inventor and entrepreneur resources, because that's going to tell you information about a pro bono program, about where to find search help. It gives you all that kind of information if you go there first. Speaking of help, as I said before, main office, headquarters is located here. We do have 4 other regional offices, and they cover those geographic areas. The Rocky Mountain region in Denver, Silicon Valley, and Texas, and Detroit. And of course, you can use this QR code. Again, you'll have the slides, but you can find this information on our website as well. I do have a handout over here for the PTRCs. And the PTRCs are libraries. They're either on college campuses or they're public libraries where there's a librarian that can help you begin your patent or trademark search. They won't do it for you, but they'll help you get started with the search. Okay, so those are great resources to find, there's one, I wanna say it's at College Park, is where the one here is in Maryland, but, you can check that out if you're interested in learning to search. Inclusive innovation, the USPTO is working hard to make sure that we include all types of inventors. Typically, you will find the names of men on patent applications and patent grants, not women. Less than 13% of named inventors were women that we found recently, so we are making a conscious effort to reach out to rural populations, underserved populations, women, minorities. We wanna make sure that everybody's included in the ecosystem, because the more ideas and more inventions we have, the better our economy and our world will be. So we're really making a conscious effort to do that. You'll also find stories of innovators on our website as well. A couple of months ago, we had a story of two brothers who created, I forgot what it's called, but it's a clip that you attach to your Christmas tree so that the ornaments don't fall off, because their dog would walk by and the dog tail would knock off the ornaments. So they created this clip that keeps the ornaments attached to the tree. Seems really simple, but it wasn't out there. No one had ever created anything like that before. So your ideas can be grandiose or they can be simple. All it has to do is meet a need and be different. Okay, again, Council for Inclusive Innovation is part of the work I was talking about, where we're trying to reach out to populations across the country, especially in pockets where there is IP deserts, particularly in, say, places like Wyoming and Montana, because there's not a lot of, not that people aren't innovative, it's just that they don't think about inventions and they don't think about protecting their intellectual property. So I'm glad you guys are here. You're thinking about that already. As I mentioned before, the inventor and entrepreneur resources, as you can see, here it tells you how to get started, and it's gonna go over the types of IP, different types of patent bases and trademark bases. It tells you what to do before you apply, where to get help, how to apply, how to protect yourself, other resources. Okay, so it's all kinds of information there that will be very helpful for you as young entrepreneurs. Again, same thing here, access resources for yourselves, how to engage with experts. Now, we don't recommend patent attorneys or patent agents, but we do have a list of registered attorneys and practitioners on our website if you're interested in getting a patent attorney or agent. The difference between a patent attorney and a patent agent is a patent attorney can litigate. A patent agent also has, the authority to help you draft your claims and your application as well, but they can't litigate. If you need more information, we have an Inventor Assistance Center. They're open from 8:30 to 8 every day, except for federal holidays and weekends. There's a phone number that you can call. Same thing with the Trademark Assistance Center. You can call and get information about patents or trademarks. If you are filing a patent on your own, we call those pro se applicants. So as a pro se applicant, you can get more information. We do have a special art unit where they work with pro se applicants on their patent applications. There's free legal assistance. We have the Patent Pro Bono program. You have to meet a certain qualification for being eligible for the Pro Bono program. We also have the Law School Clinic Certification Program, where we have law students working with attorneys to help prosecute your patent application. When I say prosecute your patent application, I mean in the USPTO, not in court. There's more information about the Pro Bono program. You must have income 300% below the federal poverty guidelines in order to qualify for that. Network across the U.S. Law school clinics, as I mentioned before. Information again is on our website, and these are law school students that are working with attorneys to help move your application through the USPTO. People always want to know how much it's going to cost. Well, it depends. We have undiscounted amount for everyone, but if you qualify as a small entity, you can reduce your fees 50%. If you qualify for a micro entity, you can reduce your fees by 75%, okay? This one has more stipulations. You can't have more than 4 previously filed applications, and your income must not be greater than 3 times the median income. Just like I came here today, we have free seminars, webinars on our website. You can click on any of those and attend. There's a search tool that we have just rolled out within the last month. There are webinars on that will help you search. The new search tool is more in line with what patent examiners use, so it's very helpful if you want to try that. There are all kinds of seminars, webinars available on our website, and they're all free. You can even subscribe to receive alerts from the Patent and Trademark Office if you're interested. Are there any questions? Any other questions? Yes, ma'am.
If you wanted to update, say, like a software that you copyrighted, do you get a whole new copyright for that, or do you just change the original one?
I'm not sure because I don't work with copyrights, but I would think there would be a new copyright application. But contact the Library of Congress, the Copyright Office. But I would think it would be a new application.
Okay, before I officially thank Robin, I also want to tell you that there's a resource here on campus. We have a tech transfer office. Wendy Martin is outstanding. If you have something, after you go through all this and do your homework first, but you still have additional questions and need a little more guidance, you can connect with Kevin, with me. We can make that connection for you, but she's right here on campus and she'll be happy to talk to you. She's really good about that. So Robin, this was outstanding. You put a lot of information and gave us great examples. So thank you so very much. We appreciate it.
And the other thing I would like to do is, there's a national patent drafting competition. I'm going to get more information so that you guys can think about participating in that. It would really help to solidify some of the things that I talked about. And if you decide that you want to seek a patent, it will help you to figure out what do I need to do so that either I can do it myself, or when I talk to an attorney, I know what information to give him or her. Okay.
And she has a wealth of materials here for you to pick up and take with you. We will post this on our website, and you've made the slides available to me, so we'll also make that available to everyone.
Awesome.
So again, Robin, thank you so very much.